My name is Edward Blum. I'm a visiting fellow at the American Enterprise Institute and the founder and director of the Project on Fair Representation. The American Enterprise Institute and the Project on Fair Representation are two separate organizations. My role at AEI is that of a visiting fellow who studies, writes, advocates, and educates Congress and the broader community about issues of law and the intersection of race and ethnicity. The Project on Fair Representation is a legal defense foundation. We provide counsel to individuals and jurisdictions who wish to challenge race-based laws, whether it's in the fields of employment, voting, education, or contracting. The Project on Fair Representation was founded in 2005, and it was founded as an advocacy organization, not a litigation organization. The mission was to persuade and educate Congress and the administration about modernizing the Voting Rights Act. The Voting Rights Act was coming up for reauthorization in 2007. The mission of the Project on Fair Representation was to provide a framework for Congress to update, modernize those provisions that were first passed in 1965. Well, the Project on Fair Representation began as a two-person entity. And like many two-person entities in Washington, the two persons went in different directions. I have respect for my co-founder, who is still active in the movement, but I decided that after some initial meetings with Congress and the administration about the likelihood of making any changes to the Voting Rights Act at its reauthorization, that the only solution would be to challenge this in the courts, and I think that's where our paths diverged. Well, a number of us spent better than 3 or 4 months on Capitol Hill meeting with various congressional leaders, talking about the pitfalls and the problems of the Voting Rights Act, Section 4 and Section 5 specifically. It became very apparent after the first meeting or two that we were not going to be very persuasive to members of Congress. These were not necessarily members of Congress that were Democrats and liberals. We weren't going to be persuasive to anyone, especially Republicans and especially conservatives, who over the years had come to believe that these provisions of the Voting Rights Act actually benefited them in the drawing of their safe Republican districts. We took our campaign from Capitol Hill over to the White House and encountered pretty much the same story. Everyone was polite, everyone was very understanding, but after a few months it became evident that the only way these provisions were ever going to be modified or struck down would be through the courts. The Project on Fair Representation really is a sibling to an organization that I started back in 1992. The story really begins in 1990 when my wife and I were living in a suburb of Houston, and our daughter was accepted to college, and we decided that we no longer wanted to live in suburban Houston, but instead wanted to live closer to the inner city. So we found a townhouse near the Museum District in Houston. I registered to vote in this new district, and when I went to vote in 1990, the Republican Party had not fielded a candidate to run against the incumbent Democrat. This bothered me. I always think that there should be a choice, and not to turn this into a super long story, but 2 years later, I found myself as the Republican nominee running to represent the voters of the 18th Congressional District of Texas, a mostly inner city district, a newly drawn district that had a slight majority African American population. During the campaign, My wife and I went door to door throughout the district, knocking on doors, meeting people, and handing out campaign literature. This was long before the internet and GPS allowed you to pinpoint where people lived. It became apparent that the district that I was running to represent was badly gerrymandered. My wife would be on one side of a garden variety Houston street, and I would be on the other side of this street. One side would be primarily African American, the other side would be primarily Latino. And those streets it became very apparent after just a few weeks of knocking on doors that garden variety Houston streets had been gerrymandered block by block in order to create safe racial districts. For instance, an apartment complex on one side of the street that was primarily African American would be drawn into the 18th Congressional District. An apartment complex on the other side of the street that was primarily Hispanic would be drawn into a different congressional district. This didn't happen just once. This happened dozens and dozens and dozens of times. So that when you looked at the shape of the 18th Congressional District, it ran for many dozens of miles in one direction and many dozens of miles in a different direction, with the goal of harvesting African Americans out of multiracial, multi-ethnic neighborhoods in order to create safe majority-minority districts. This didn't just happen in Houston, this happened in Dallas, it happened in Atlanta, it happened in Charlotte, it happened throughout the Deep South. I didn't attribute my loss to the gerrymandering. I think my loss occurred because it was an overwhelmingly Democrat district, and being young and idealistic, I decided to run anyway. What bothered me about losing was that it wasn't the electoral outcome. It was the fact that these neighborhoods that were multiracial and multi-ethnic were split apart to create a racial outcome. When I went door to door, neighbors were concerned about their neighborhood, their local schools, the issues of crime, whether businesses were coming and going. That's what they were interested in. They weren't interested in the fact that, well, my little neighborhood is connected to another African American neighborhood 75 miles due east of here, and our representative is black. That's not what people cared about. They cared about their neighborhood. So, I guess about 5 or 6 months after the election, I read in the New York Times that a similarly shaped congressional district in North Carolina was under attack for the same kind of racial gerrymandering that I believe had occurred in the state of Texas. I thought that if there was a good case in North Carolina, there very well may be a good case in Texas. Now, I had never sued anyone prior in my life, and knock wood, I had never been sued. I pulled together sort of a ragtag group of volunteers. I found one lawyer in Monroe, Louisiana, who I agreed to pay out of my own pocket a few $1,000s a month to litigate this. And in 1993, we sued the state of Texas, arguing that the congressional plan, as enacted in 1990, was unconstitutional. It was a racial gerrymander that disfigured traditional redistricting principles. That case was styled Bush versus Vera. We went before a 3-judge panel in Houston, and we won. The state of Texas appealed that case to the United States Supreme Court, and lo and behold, the court took it up. We made arguments in 1995, and the case came down in 1996. We won that case in an opinion authored by Justice O'Connor, and my business associates back in Houston recognized that date as the date in which my interest in public finance and investments started to wane, and my interest in litigation and advocacy started to accelerate. While I greatly enjoyed the experience of running for public office, I was also, greatly relieved that it was over. And I think I had had my fill of electoral politics and decided that I would stay involved in public policy, an area in which I've had a long-standing interest. But the ballot box would not be the way I would go about doing this. Because the outcome of Bush versus Vera was so satisfying, and by that I mean Texas had to redraw its congressional districts after Bush v. Vera came down. Texas was unable to do it, but the three-judge panel did. And when you compare the shape of the districts that the three-judge panel drew and compare those to the districts that the state of Texas drew, what happened was that these multiracial neighborhoods were basically put back together. No, they weren't circles and squares and oblongs. They still had some odd shapes here and there. But the block by block harvesting of blacks, whites, and Latinos to be put into different districts that ran many dozens of miles in different directions, that came to an end in the state of Texas with that lawsuit. So what I did, I found that so gratifying that I asked a social scientist, a political scientist that helped with that case, to compile a list of the most racially gerrymandered congressional districts in the country, down to the least racially gerrymandered congressional districts in the country. And that list provided me a roadmap to go and recruit plaintiffs in the states of New York, Virginia, South Carolina, Florida, and other places to apply the opinion that came out of Bush versus Vera and came out of some of the other racial gerrymandering cases to those congressional redistricting plans. I basically took our legal team on the road. We went to New York, sued the state of New York, went to Virginia, South Carolina, and we were successful in all of those states. And all of those states were compelled to redraw some, not all, but some of their districts so that traditional redistricting principles were remedied and put back together. Well, I think I've described myself, and I think it's a reasonable description, as Yenta the matchmaker. If you remember Fiddler on the Roof, my role in not only Bush versus Vera, but the subsequent cases that followed, was to really sort of identify an area of the law that I think needed changing, or identify a policy that needed revisiting. Recruit a plaintiff to do that, hire a legal team, raise the funds to pay the legal team, and then basically try to keep the train on track and running on time. What skills does that require? I don't really think there are any special skills for that, other than I do recognize that I'm a one-trick pony. I know one area of the law fairly well. I don't know any other areas of the law at all. And perhaps that focus has allowed me to kind of to tease out the most important issues that surround this advocacy and not let it get cluttered up with tangential things. I grew up in a liberal Jewish household. My mom and dad were Roosevelt Truman Democrats. Our household was pro-civil rights. I am probably the first Republican that my mother ever met. Race was something that was an issue, I think, in Jewish households in the 50s and 60s. Jews perhaps more than, I think there is a long history of Jewish advocacy in the civil rights movement. I think that looking at the early years of the NAACP and other racial advocacy groups, Jews played a very prominent role. My parents were not foot soldiers in that movement, but wrote checks when they could, or surely taught the family that race and ethnicity, have no bearing, as does religion, in our public lives. So I've had an interest in race, since I was a teenager. I think what crystallized my advocacy in this area was just seeing how the state of Texas, block by block, harvested out individuals based on their race in order to create these racially homogeneous voting districts. That is not what electoral districts are all about. The traditional districting principles always kept neighborhoods together. When I was a kid, you knew where the African American district was. You kind of knew where the Hispanic district was. That's because blacks and Hispanics lived in ghettos and barrios. Once African Americans and Latinos started moving to the suburbs in the 70s and 80s and 90s, it was not necessary to continue drawing districts that went out and harvested these individuals and neighborhoods in order to maintain these districts. So I think that was the defining moment for me that got me interested in this movement. I guess I can probably answer that question best by giving you an anecdote. When I won the primary and became the nominee, I went to a very prominent Republican incumbent who had represented one of the Houston suburban districts for many, many years. Some of his neighborhoods had been redrawn into the new 18th Congressional District. And I went to him and asked him if he could help me identify some of the prominent African American businessmen, clergymen, and leaders who used to be in his district, because they were now drawn into the 18th Congressional District, and I wanted to meet them. And his answer was, he didn't know any. He just didn't know any of the African Americans in his district. He had a 80% Anglo district. He didn't attend African American church events. He didn't attend African American high school graduation events. He just didn't reach out to that community. He was a little sheepish about it, but that's the outcome of drawing districts in which race is the predominant issue. Race is the predominant factor. There is no need for representatives to reach outside of their racial base if we're going to have race-based districting. In each case that we filed, from Texas to New York to South Carolina, the justification for creating these bizarrely shaped bug splat districts was that Section 5 of the Voting Rights Act compels us to do this. Section 5 is the reason that we've had to create a district that went 175 miles down an interstate, just plucking out African Americans out of rural communities in order to create these safe African American districts. It was because of Section 5 that these states did it. That was the justification. And to me, if Section 5 was causing this kind of mischief, then Section 5 needed to be changed or updated or struck down. Well, Section 5 of the Voting Rights Act not only controlled the shape of those congressional districts and the districts from city council to county commissioner throughout these covered jurisdictions. It also controlled, a lot of other things: polling place location, voting hours, voter ID, things like that. But I was interested in changing Section 5 because of the command that these bizarrely shaped, what Justice O'Connor called racial apartheid districts, were blotting what I believed was the traditional sense of democratic geographic units as it pertains to election districts. Well, I didn't really have much fear that Congress would become, all white again in the Deep South, or there wouldn't be any Latinos in New York. And as it turns out, we have a laboratory for this. What happened in the state of Texas and New York and Virginia and South Carolina and Louisiana after these districts were redrawn? Well, African Americans, the African American representatives remain the same. Same with the Latino representatives. Nothing really changed in terms of the sort of the color of our congressional delegations. What I think did change, and what I hope will continue to change, is that as districts become more multiracial and less homogeneous, that white conservative Republicans are going to have to reach out and learn about their minority communities, and African American and Latino elected officials are going to have to reach out and learn more about their white conservative communities. There is a big body of literature that suggests that perhaps one of the reasons Congress is so polarized today is because of the creation of racially homogenous groups. It's not the only reason, of course, but it's one of the reasons, and it's my hope that as African Americans and Latinos continue to move out to the suburbs and our inner cities become more multiracial, that these districts become less politically polarized now that they no longer have to comport with Section 5 of the Voting Rights Act. Well, I'll go back to an interesting anecdote. After the Supreme Court struck down the Texas Congressional Redistricting Plan and the 3-judge panel in Texas redrew districts, Congresswoman Sheila Jackson Lee, who defeated the man I ran against in 1992 in the Democrat primary, did something very interesting. She went to the new neighborhoods that were added to her district and started meeting voters. The news cameras followed her, going door to door, introducing herself to these, new conservative, formerly, Republican voters. I think that's an important anecdote. I think now we can see the participation of African Americans in greater numbers at events that they typically didn't go to. And I think surely the Republican Party is attempting to reach out to minority communities, specifically Latino communities in the Deep South and the West, trying to do something that they didn't do before. So I think the outcome of these new, less gerrymandered multiracial districts could very well benefit both political parties. Well, it's very interesting. When all of these districts were challenged in the 90s, Texas, New York, Virginia, North Carolina, South Carolina, Georgia, the Republicans were the ones that were the most against these lawsuits. The Republicans saw the benefit, the electoral benefit, of creating safe, heavily packed majority-minority districts. It's very rare, I think, in the annals of Supreme Court advocacy, that Newt Gingrich and Congressman John Lewis co-authored an amicus brief to the Supreme Court in which they argued that the creation of African American districts in the state of Georgia needed to be upheld. Well, what's in it for both of those? Well, Newt Gingrich saw that the districts surrounding safe African American districts became Republican. John Lewis and others in the Congressional Black Caucus saw that, hey, if you draw a 65% African American district, we're going to have a lot of black faces in Congress, and that's a good thing too. So I think that amicus brief tells us a great deal about the politics of racial redistricting and how two very sort of opposite poles came together to create an electoral advantage for each. I am not an expert on voter ID, and my passion doesn't burn brightly one way or the other. I think for the most part, asking a voter for some identification makes sense. On the other hand, I can see where making access to that ID so onerous that it dissuades people from voting is also a very bad idea. I think what Shelby County did in terms of voter ID was just to put these jurisdictions at the same place as those jurisdictions outside of Section 5 of the Voting Rights Act. So if the Department of Justice has a problem with Texas voter ID, Texas now needs to be treated the same way as Indiana. If the Department of Justice doesn't like what South Carolina did with their voter ID laws or their early voting hours, then South Carolina is going to be treated just the same way as Tennessee. And I don't think that's a bad outcome at all. I think that restores a very important constitutional order to our system of government. It's a very serious consequence for Congress to strike down a statute passed by the United States Congress. I recognize that. I also recognize that it's done. And it's done not frequently, but infrequently, and in cases of great import. Congress had a record before it in 2006 that, in the opinion of those of us who see the Voting Rights Act through conservative eyes, and even those who see the Voting Rights Act through liberal eyes, warned Congress repeatedly that the record before them was insufficient to reauthorize the act as it was passed in 1965. This came from very knowledgeable, highly acclaimed scholars at half a dozen institutions. Law professors testified, don't do it. Congress took the easy route. They did not want to open this to debate. They didn't want to tinker with the formula. The Supreme Court in 2009 gave them an opportunity to go back and tinker with the formula when Northwest Municipal Utility District number 1 versus Holder came down. That was a bell that Congress heard that they just didn't respond to. So it seems to me that the principle that Congress's acts should really rarely be revisited, while valid and important, should not have been upheld in Shelby County. Well, what I'm saying is that Congress took the easy road out. I testified at one of the congressional hearings. I attended every one of the congressional hearings. And while I didn't read every one of the 15,000 pages of the congressional record, I did look at every one of the 15,000 pages of the congressional record. And I concluded, and I think many of us on the left and right concluded, that while voluminous and while often passionate in their testimony, the record did not justify keeping the same coverage formula in 2006 as we had in 1982, and then prior to that in 1965. After the 1990 round of litigation, Texas, New York, Virginia, etc., the 2001 redistricting outcomes were vastly improved. Here I have a modest knowledge about recruiting plaintiffs, hiring counsel, and funding all of this. And looking at the districts that came out of these states in 2001, I couldn't find a case to bring a new major round of litigation challenging those plans. So to the degree that Vera and Shaw v. Reno and the other cases sent a signal to legislative bodies throughout the Deep South that they couldn't continue doing this, they had to comport to more traditional redistricting criteria, then I think those cases were a very big success. So because of, I think, some of the success that I had with the other racial gerrymandering cases throughout the 90s, people started contacting me and asking me for help with kids who had been denied admission to magnet school programs. Parents contacted me asking me for help when their kids were denied to Vanguard school systems throughout Florida and Texas and other jurisdictions. So in some respects, the Bush v. Vera and the subsequent other cases sort of established me in some capacity as someone to contact if you think your race or your ethnicity has been used against you when you've applied to a school, or whether you applied for a job, or whether you applied for a contract. So I started sort of broadening my litigation portfolio from voting to include these other areas of public policy as well. Well, beginning in 2005, I had at that point provided counsel in probably 15 different lawsuits involving various aspects of the Voting Rights Act, various aspects of race-based affirmative action in education, and race-based affirmative action in contracting. In 2005, I guess I made a decision that I was hopeful that I could make big law, that my focus would shift from applying the law to really trying to change it in significant ways. So beginning in 2005, I identified 2 or 3 areas, voting, education most prominently, as areas in which my goal was, through the courts, to restore the original vision of the civil rights movement. And that vision, as I grew up with it, was that your race and your ethnicity should not be a factor that is used to help you in some way or to harm you in some way. So that, beginning in 2005, was the point in which I started to put together I think a more adventurous litigation strategy. I think we all do, and I think it's just not my little organization, but other organizations like the Institute for Justice or the Pacific Legal Foundation or the ACLU or some of the gay rights legal defense foundations. The NAACP provided the model for all of us, and it was a model that was successful and a model that we all strive to emulate. Well, it's hard for me to get a good feel on what the politics of the bench really are. And I use the last 3 days of last term as an example. The court came out on Monday, June, I believe the 24th, with the Fisher case in a 7-1 opinion, sending it back with a much higher standard to be applied for the use of race in university admissions. The next day came down the Voting Rights Act, and then the following day came down the gay rights cases. It seems to me that the court wants America and our legislative bodies to get out of the classification business. They want our institutions of higher education, our government, to stop classifying people and treating them differently, whether it comes to race, ethnicity, or their sexual inclinations. And I think that that's a trend that we've seen develop over the last 10 or 15 years, and I suspect it's going to be a trend that we see continue as long as we have this court. When it comes to race and ethnicity, I think the court has been, over the last 25 years, slowly and carefully, probably beginning with Croson, moving the nation to a point that the use of race and ethnicity must be fully abandoned by some end point. I'm not necessarily talking about Justice O'Connor's 25 years with the Grutter and Gratz cases, but each opinion seems to add incrementally to a body and a doctrine that the court is signaling that race and ethnicity needs to come to an end. I think that has accelerated over the last 7 or 8 years, but I think the trend lines have been in place since at least Croson in the late 80s. I think there is, great passion about the makeup of the court among both liberals and conservatives. And I think that's emblematic about, as we see in the debate, about who should retire and when they should retire. So I'm not arguing that the makeup of the court doesn't mean anything. What I am arguing, though, is that the members of this court and future members of this court are on a historical arc that I believe will bring our laws and our public policies away from the use of race and ethnicity, more toward an ideal in which race and ethnicity are simply not factors at all. Well, my real interest in education, again, began back in Houston in the 1990s when I received a phone call from some parents whose children had been denied admission to a Houston Independent School District magnet school. This school was designed for kids who were academically gifted, and there weren't very many of these academically gifted magnet schools in HISD back in the early 90s. The mother said that her daughter had applied and taken all the exams and was told, however, that the school set aside 60% of its slots for African Americans and Hispanics and 40% of its slots for Anglos, and that the Anglo slots had already been filled. Well, quotas are anathema to our civil rights laws. Racial balancing is anathema to our civil rights laws. This wasn't something that HISD hid from anyone. It wasn't something that they were trying to achieve kind of with smoke and mirrors. This was quite prominently posted. This is what the outcome of this school is going to be. I hired counsel, recruited counsel. We filed a lawsuit against Houston Independent School District. 4 days before trial, HISD came and said, "Well, you're right. We're not going to go to trial. We're going to admit these kids. We're going to end the quota, and on top of that, we are going to take resources and open up 2 or 3 more campuses throughout HISD to accommodate kids of all races who want to be in a vanguard and an elite academic environment like this." So that's a pretty good outcome. That's a happy outcome. No trial, which is always a happy outcome for lawyers. More schools that will accommodate these kids, and the end of racial quotas and balancing in a public institution. Well, I got from Houston Independent School District to Fisher via Grutter and Gratz. Grutter and Gratz were not my cases, but of course I was deeply interested in them and deeply saddened over the Grutter case, in which the court decided that racial diversity was a compelling governmental interest that allowed universities to classify students by race and treat them differently by race. I think that was really a defining moment for many of us who labor in this movement, that opinion one day hopefully would be revisited. It was interesting that the day that opinion came down was the day that the University of Texas announced that they were going to add racial classifications and preferences to their race-blind admissions policies. So Grutter led to Fisher because the University of Texas decided that it was going to reintroduce race-based affirmative action on top of a race-neutral, highly effective top 10% plan that had been in effect at UT for the prior 7 or 8 years. That moment, that announcement, was basically the beginning of the Fisher case. Well, finding students, 17 and 18-year-olds, who have been rejected from the school of their dreams, who are now about to begin a 4-year college career someplace else, and persuade them to file a lawsuit challenging the admissions policies of the school that rejected them, is indeed not an easy thing to do. It's not easy to persuade teenagers to do this. It's even harder to persuade their parents to do something like this. So, whether it's the Project on Fair Representation or the Pacific Legal Foundation or Institute for Justice or Defenders of Wildlife or any of the environmental defense groups, one has to cast a very wide net in order to find someone like this. I did a number of different things. I launched a website called utnotfair.org. I gave speeches at the University of Texas and other college campuses. I networked. I cold called. I made a nuisance of myself, and ended up with a handful of decent prospects. Abigail Fisher's father and I had been acquainted from my years in Houston, and Abby turned out to be the ideal plaintiff. There were others that I could have chosen prior to Abby, but I chose not to. Variety of reasons. One or two academic backgrounds weren't nearly as meritorious as I wanted. Also, you have to find kids and parents whose heart is in the right place. These are issues that are very sensitive and polarizing in our nation today. I have to find people who are of good wills, who do not have an axe to grind, who don't have theories about the state of American cultural affairs and are going to use a lawsuit as a platform to share their ideas about American society. So Abby and I think the other individuals that I've provided counsel to have fit the bill of good hearts, the right motivation, and turned out to be, very sympathetic, ideal plaintiffs. We're a litigation organization. We speak to the courts, and it is often inadvisable for plaintiffs to speak outside of those courts. Judges read newspapers. Justices watch television. The last thing that anybody in my business, and whether it's litigating race or litigating the environment or litigating gay rights, is to have plaintiffs that are unsympathetic. And so I think it's very important to find just the right people to go before judges and justices. Well, because I'm not a lawyer, I am blessed with the acquaintance of a great many very smart, well-experienced lawyers from coast to coast, not just here within the sort of the Washington, D.C. Supreme Court bar, but all over. And I have made a complete nudge of myself among those folks. Fortunately, they will still take my calls and they will still answer my emails. That community of lawyers really is the most important thing I have going for me. In terms of what I do outside of those lawyers, how I think of a case, I have learned that when I identify an area of the law, whether it's education or voting, I have the luxury of starting with what I want the Supreme Court opinion to read and then working backwards to the district court. Most lawyers don't have that latitude. They don't have that. They're I think for the most part restrained in thinking that way. So I think of what I want that opinion to read. I think of what the Eighth Circuit Court of Appeals might say about a case. Then I think about what a district judge in the Eighth Circuit might say about a case. And I kind of work my way from that opinion to the circuit judge and see if I'm sort of on the right track. I take that theory and then run it by my buddies, who often will disabuse me of whatever ideas I've come up with. But sometimes we hit upon something. And that, I think, really was sort of emblematic of the Northwest Austin Municipal Utility District versus Holder. I thought we should go immediately for striking down Section 4 and Section 5. Whereas counsel, brilliant guys, said, let's put a chop on the log first. Let's give the court the opportunity to broaden this a little bit, avoid some constitutional decision of great importance. Let's let the court give Congress another shot at it. So that's how that case was framed. Really kind of framed over my objection, actually. But as it turned out, Northwest Austin was the first chop on the log that then led to Shelby County. So the process of beginning with what you want that opinion to read, back to the appellate court, back to the district court is sort of my model. I think it's enormously helpful and probably dispositive for me and what I'm trying to accomplish to have an appellate litigator, a Supreme Court appellate litigator at the district court working on the complaint. There has to be that kind of connection between that judge sitting in a chair in Austin, Texas, with the Chief Justice of the United States announcing the case. It's better to have that group of attorneys with you the entire way, keeping their eye on what the ultimate goal is, and that is the Chief Justice announcing that case. I think the current project now, and a very important one for me, is to apply the doctrine that the court handed us in Fisher to the higher education community at large. So to that end, I have now targeted, much as I targeted the University of Texas back in 2002, 2003, 2004, I've now targeted 3 schools that I believe are not in compliance with the doctrine that the court gave us in Fisher. Those 3 schools are Harvard University, the University of North Carolina, Chapel Hill, and the University of Wisconsin at Madison. It is my belief that for various reasons, those 3 schools are vulnerable to a legal challenge to their admissions policies. And it is my hope that just as I was able to recruit Abigail Fisher to sue UT, that I will be able to recruit plaintiffs to sue those 3 schools and perhaps others. It's my belief that a court outside of the Supreme Court will look at the facts in each 3 of these schools and conclude that they are out of compliance with the new strict scrutiny standard handed down by Fisher. And if we win at those levels, then I'm delighted. I perhaps anticipate that those schools would then appeal to the United States Supreme Court, and we may have additional arguments on additional issues there. But it's my belief that those 3 schools with litigation can be decided rather narrowly. Well, I think there's an interesting arc that we can discuss with the Fisher case. As some may remember, Heman Sweat applied to the University of Texas School of Law in the 50s and was denied admission. Heman Sweat was a Houston area mail carrier who met all of the qualifications to attend the University of Texas School of Law. He was denied because of his race. He wanted to attend the University of Texas as just an applicant who met the qualifications. He didn't want his race to be used as a factor to harm him, obviously, but he didn't want his race to be used as a factor to help him either. He didn't want the bar raised, and he didn't want the bar lowered. Abigail Fisher basically made the same argument. She did not want the bar raised for her because she was white. She didn't want it lowered for her either. I think that arc that connects Heman Sweat to Abigail Fisher is the founding principle of the civil rights movement. And for 40 years, that principle has evolved in ways that are hard to recognize from the time that my mother and father And so many advocated for desegregation in the 50s and 60s. So to the degree that I can provide cases that will continue to restore that original vision, then that's what I hope to do. Yes, I believe that the Supreme Court has veered in directions it should not have veered concerning race and ethnicity. But I think it has been a slow process that the court has now started to recognize that slowly, carefully, judiciously, they're going to lead the law back to the point where an individual is judged not by race and ethnicity, but by factors outside of that.